A couple minutes.
There we go. Yeah, we have quite a few people logging on right here at 6.
Great.
So I'll just do a little introduction while we let the rest of the people log on. Thank you, everybody, for logging on today. I'm Claire Tibbetts. I'm the Executive Director of the Autism Society of Greater New Orleans. You may or may not have met me before, and I'm really excited to be partnering with Chip Morrison again with Morrison Law. Chip has been really a great partner for the last few years, partnering with us on a few different events each year, and especially including educational webinars. And so I'm really excited to have Chip with us again today to share this information with you all because it is a very important but complicated topic. You can take it away, Chip.
All right. Thank you, Claire. I appreciate it again. And thank you to the Greater New Orleans Autism Society for allowing us to present on this topic. This is, special needs planning is something that it's very important to us. We try to make it as absolutely easy as possible for our clients to understand because there's so many rules and regulations regarding what you can and can't do with special needs planning. So we really try to take the opportunity with each and every client to explain it to them, no legalese, none of this fancy jargon, just in everyday terms. And, our clients get a lot out of it. More importantly, the care plan that they design for their children is it's a solid plan. And that's really what our goal is. Um, so we'll go ahead and get started. And well,
H. What
oops,
the? What are this? That's just the hotels I wrote down for
there you
last
go.
time.
Hey,
All
if
right.
you've just come into the meeting and you're not currently muted, could you please go ahead and mute yourself? If you don't know how to mute yourself, I can mute you for you.
All right. Uh,
Chip, you ended up muted.
yeah.
There you go.
Yeah, I don't know how that happens. Thank you for everyone being here, and hopefully we won't have any more technical difficulties. All right, so let me just take a quick second, introduce myself. I'm Chip Morrison. I'm an estate planning attorney. What that means is, and I'm board certified estate planning attorney. All that means is that this is all I do all day, every day. This is all I want to do. I don't want to do anything different. We joke around our office that we make three kinds of pizzas, wills, trust, and probate successions. That's all we do. That's all we're going to do. We've partnered with the Autism Society, Greater New Orleans Autism Society, for quite a few years. One of our other partnerships that we're very proud of is the Alzheimer's Association. So it's just something that, we enjoy doing. We like to give back, and, we serve as community advocates. So this is just a picture of our whole team. I put this up here really for the purpose of letting you know that it's not just me. It's everyone that's involved on our team. So our clients are going to get a lot of support from everyone. And just because I may be unavailable for a couple of days, that doesn't mean your questions won't get answered, or, if you need something notarized, that can't happen. We're all here to help our clients. So what do we do as far as how do we help clients? You can see on the screen, these are the different aspects of what we do in our office day in and day out. And basically, what we're trying to do here is, essentially be your trusted advisor. We blend estate planning, wealth planning strategies, and they're all backed by board certified expertise. So it's really a big benefit to our clients. And you'll see on the screen the elder law, the special needs planning. Believe it or not, those two go hand in hand. And most people get caught up on special needs planning is only for special needs children. Well, that's not always the case. Sometimes our parents, our grandparents need special needs planning. So there's a lot of synergies between the planning types. And these are all the things that we proudly help our clients with. So, what are we trying to get out of tonight? What are our goals? Well, number one, we really want to understand and start thinking about a life care plan for, our family members that may have special needs. The second thing that we want to make sure that everyone walks away this evening, they have a better understanding of all the different options that are available. Estate planning, it really is not just, okay, we have your will, we have your powers of attorney, we're going to put it in this box, and that's it. That's just the beginning of it. That's just the foundation to an estate plan. We may need a special needs trust. We may be able to accomplish preventing your child from losing government benefits by use of what's called an ABLE account. And we'll go through that in a little bit. The biggest thing we want to do, though, is inform our clients, educate our clients, and make sure they're not unprepared when that moment arrives, when they lose capacity, when our clients pass away, or some healthcare emergency happens. That's really what we're trying to do here. Um, and the thing about it is that, estate planning and special needs planning, it's very serious work, because we're planning for that defining moment that's going to come to each and one of our lives. It's going to come, to your child's life. And what that moment is when you can't speak for your child anymore. When your child, under the law, when your child reaches a certain age, you can't make decisions for them anymore. And the important thing to remember is what you plan in advance, that is what's going to speak for them. Those documents, those planning written instruments will speak for them and protect your child when you cannot. So it's a lot of there's a lot of considerations with special needs planning, and it just, the screen on that you can see on your the slide you can see on your screen really boils it down. What are you going to leave your children with? What are you going to leave your loved ones with? Clarity or confusion? When you have a plan in place, they're going to have clarity. They're going to know what you would have wanted. Your brother that you picked to be in charge of your special needs child, he's going to have a written set of instructions. He's going to know what to do, what not to do, and that's clarity. That's saving him, that's saving your family a tremendous amount of grief. And the confusion part is when you don't plan, when you don't have written instructions on how you want your loved one, your child's affairs to be administered. And basically, in that part, with the confusion part, it's going to be silence. If you haven't done any planning, then your family is going to be left with silence. And unfortunately, when there's silence, that's when the law is going to speak. The default rules come into play. And it may not be what you wanted. So that's why planning ahead is so important. And as you can see on a screen, there's just simply no second chances when it comes to estate planning. You either get it done or it's going to be an issue of silence, and the law decides who's going to be in charge of your child. And that's what we want to avoid. All right, just a couple caregiver statistics that we like to do every year. We don't have the 2026 numbers, but this is from 2025. If you look at the screen, there are a tremendous amount of people that are caregivers. And yeah, if you're taking care of a family member and you're going over there 4 or 5 times a week, or your parent lives with you in your house, you meet the definition of a caregiver. And right now in our country, we've got about 53 million people that are caregivers. And you can see it's a really astounding number on the bottom. There are about 14 million caregivers for children with special needs, and minor children with special needs, I should say. So those are some pretty big numbers, and it just drives home the point that the planning is so important. Okay, one of the things that we really want to avoid at all costs are these worst case scenario type of issues. If you have a child with special needs and you don't do any planning or you never get around to it, and who knows what that means? Who knows what getting or not getting around to it, what the real definition of that is. We've all heard it before, procrastination. But the problem with procrastination is tomorrow, it's always in the future. It never comes. And so we really congratulate everyone for taking the steps to make sure these important tasks are taken care of. Because if you die or or you as the parent have a healthcare crisis, who's going to take care of your child? Who's going to be the appointed guardian or tutor for your child? Who's going to make sure your child doesn't lose any government benefits? Who's going to advocate for your child? These are all of the things that we want to make sure, the old what is the picture of the ostrich with its head in the sand? We really we want to make sure everyone knows how important this is, and that doesn't happen to them. We're not sitting there, sticking our heads in the sand, acting like everything's fine, because there's a lot of things that we can do on the front end that will make life a tremendous amount easier for your children when you're no longer here. All right. As we kind of said, what our goals are for this presentation, we have to look at what the goals are for our families that we help. It's very simple. They want to make sure that their children's quality of life is the utmost importance and that their children are happy. We want to make sure that we have a plan in place that's going to maximize their child's quality of life. That's it. And that's all special needs trust planning is. So before we get into the nuts and bolts about what a special needs trust is, how do they work, and things of that nature, we're going to take a little time and just kind of review some government benefits that are out there. The Autism Society is a wonderful resource to find out more about benefits. So, when you look at government benefits, you really need to break it down into two categories: means tested programs and entitlement programs. The government entitlement programs are those programs that are administered by our federal government that no matter what your income limit, no matter what your income may be, no matter what your assets may be, it doesn't matter if you're a multi-millionaire, if you meet certain criteria, you get those benefits, such as SSDI, Social Security Disability Income. Same thing with Medicare. You can be 100 trillion billionaire, and once you hit 65, you're entitled to Medicare. On the other hand, we have the means tested programs. These are the programs where the government's going to say, okay, we understand there's some disabilities there, that there's a need for it, but to make sure, we're going to go ahead and we're going to look at your income. We're going to look at your assets. We want to make sure you're below the maximum amount of assets will allow you to have, and then then you pass the means test. SSI and Medicaid are the two big ones. Those are the two programs that you cannot have you cannot have assets, countable assets over a certain level. And there's a bunch of other things out there. These bullet points are a very, very small example of some of the benefits that are available to you guys. We just want to, hit on the really big ones. All right. We have something in Louisiana, very, very similar. Of course, we have to be different in our state. We even call our laws different. We have a totally different system of laws in our state. All the other states have something called guardianships or conservatorships. And that's for children who they have issues. They cannot manage their own affairs. They have a disability. In Louisiana, we call that a tutorship, a basic same thing as a guardianship. And more specifically in Louisiana, we actually have a wonderful, what do you know? We have a good law. We have a wonderful law called continuing tutorships. And as you can see on the screen, what a continuing tutorship basically does is it acts like a super power of attorney for your child. Because once your child turns 18, and I understand they can't make decisions, they can't speak, or whatever the case may be, but once the child turns 18, your parental authority legally ends. Um, unless you do this thing called the continuing tutorship. So we really harp on this. We tell our clients over and over and over again, because a lot of times clients will come and see us and they've got a child may be 5 years old, child has, autism or Down syndrome or some disabling condition. And we tell them every year when we meet back with our clients or every few years, don't forget about the continuing tutorship because this is the only way you're going to be allowed, well, the ideal way you're going to be allowed to make decisions for your child after your child turns 18. Um, like I said before, basically it acts as a superpower of attorney for your child. It grants you the decision-making authority for your child so you can make medical decisions. You can handle your child's finances after your child turns 18. And as you see on the bottom of the screen, basically what that means is it's going to be you're going to be able to make those decisions for your children, for your child, for the rest of their lives. And the really nice part about our continuing tutorship program we have in Louisiana is that you can appoint a successor agent, a successor tutor for if something ever happens to you, then this person steps into your shoes and acts as the tutor for your child. The the guidelines for continuing tutorship basically it's going to be between the child's 15th birthday and 18th birthday, you need to get this done. No ifs, ands, or buts about it. If you do not file for a continuing tutorship before your child's 18th birthday, it's not going to happen. The court won't allow you to do this. You're going to have to go through door number two, which unfortunately is an interdiction. And we'll just touch on an interdiction in a second, but we really don't want to have to go through the interdiction. It's a lot more expensive. It's kind of embarrassing to have to go through it. It takes a lot longer, and it's just you actually have to go to court, and we don't want to have to do that. For the continuing tutorship, though, as long as you file it between the child's 15th birthday and their 18th birthday, you're golden. No problems. Your child has to meet the legal definition in order to qualify for this continuing tutorship. And basically what the courts want to see is they want to make sure that the child has meets the magic language, that they possess less than a two-thirds intellectual ability as compared to their peers, children of their same age. Um, the easiest way to do this, guys, we get a letter from your child's pediatrician. And I have to give a major shout out to most all of the pediatricians for the families that we work with. These guys and girl pediatricians are fantastic. I mean, client sends the email, "Hey doctor, this is what the lawyer says the needs to be in the letter." And those doctors, that's the fastest thing doctors do. They rip these letters out for us. And so, we always want to give a big shout out to the pediatricians who help out our clients' families. Um, if we can't get a letter, that doesn't mean from the doctor, it doesn't mean we can't do it. We just have to use some other things, such as the IEP, medical records, things of that nature. Both parents should be asking the court to do this. If one parent can't, then we need, like, if one parent's out of country or something like that, then we need to state all the reasons why. There are some issues when you have divorced parents And we want at least one of the definitely one of the parents has to petition, ask the court for this. The best practice is to have both parents ask the court for this. On the bottom bullet point is something pretty unique in Louisiana. And when I first started doing these, I was thinking, oh, I bet you it requires a coroner's certificate. The coroner has to get involved because they're going to want some kind of fee or, $100 fee for the coroner to sign a certificate, basically an affidavit. Good news is that is not true. We don't have to pay the coroner or anything. You don't pay the coroner or anything. The reason why the coroners have to file an affidavit in this proceeding is because the coroner is a chief medical officer, basically, of the parish. And one of the big functions of a coroner's office is mental health. So the courts want to see that the coroner, who's familiar with mental health, is going to be able to say, yes, I agree, this is a good idea, or no, I do not concur in this continuing tutorship. All right, something neat we have for everybody. All right, I'm asking, I just tested this and it worked. I'm asking everyone on the call, please take a picture or do the QR code, scan the QR code with your phone. That way you can pull up the special needs family timeline. This is an outstanding, handy little thing that we have for all of our clients, and it really breaks down the different aspects during the aspects during your child's life of what you need to do and when you need to do it by. And as you can see, we just talked about continuing tutorships, but on the right-hand column, once your child hits 18, we lose the continuing tutorship. We have to go to this interdiction proceeding. Okay? So I'll give everyone just a couple of minutes to do their phone and get that on downloaded because it's really, really important information. All right. Um, Yeah, wasn't sure why there's red lines on here. All right, so I don't want to beat this, to death, but you can see on the screen once the child turns 18, we lose it. We can't go forward with a continuing tutorship. Plus, the other thing to consider is a continuing tutorship is a lot less intrusive or severe than an interdiction. And with the interdiction, your child's going to lose all rights, including the right to vote. One of our famous cases we have in Louisiana, the Supreme Court basically, not basically, they did come out and say that an interdiction is is basically the civil death of a person. So that's how severe interdictions are. Okay? All right. So what else can we do? What are some planning options? We have a child with this disabling condition. What's available to the parents out there? What are some things that we can do? Well, first and foremost, we just disinherit the child. We want to make sure they keep their government benefits. So I'm just going to leave everything to their sister, everything to my disabled son's sister. That way the child can still get their government benefits. I'm going to show you in a second why that doesn't work. Secondly, of course, there's the old hope and pray plan. What do they say? Fingers crossed is not a plan. And what I mean by that is what a lot of family members will do, a lot of parents will do is they say, well, we're just going to leave everything to sister and she'll take care of brother. We know sister loves brother a lot and she's going to do the right thing and take care of him. Well, we're going to show that I know the intentions are good. I know the intentions are pure, but I'm going to show you in a few slides why that doesn't work. Another option, which we actually do a lot, is spin down. A lot of times a child will get back pay from SSI or something like that. And next thing you know, Medicaid comes in and says, oh, your child has $7,000. They can't have $7,000. You need to spend $5,000. And so we'll enter into a spin down program. There's something that's been around for quite a while now that I want all parents to know about. It's called an ABLE account. And basically, what it does is, I don't want to jump the gun here, but if there's a relatively small amount of money that we don't want to spend down, we don't want to give away or anything like that, you can go to your bank and you can open up one of these ABLE accounts, and you can take the excess. Let's just say Medicaid says you cannot have more than $2,000 worth of assets, countable assets. Same example, or just say a child gets an inheritance from an uncle that leaves them, $15,000. Instead of trying to hurry up and spend down that $15,000, we can just take that $15,000, dump it into an ABLE account, and Medicaid will say, great, thank you very much. Let's continue. And of course, what we're going to spend the most amount of time on this evening are our special needs trusts. So those are your planning options. Okay. So there are some things that we can do. Disinheriting a child, I just tell you, don't do it. It doesn't work. It's most likely going to be illegal or unlawful in Louisiana. And I'm going to show you why in 1 second. Plus, it just doesn't sit right, disinheriting a child with special needs. All right. We are extremely unique in Louisiana. We are the only state in the country that has something called forced heirship. And basically, the law sets aside a certain percentage of your estate, of everything you own when you die, and it has to go to your children if your children meet these conditions. The first condition is, of course, if you have a child under the age of 24 at the time the parent passes away, then your child's going to be a forced heir and they have to receive a portion of your estate. The second condition to be a forced heir is regardless of how old your child is when you pass away, if your child is permanently incapacitated or likely to be incapacitated because of an inherited disease or condition, they're going to be a forced heir. So, the idea of giving everything, disinheriting your child, it just simply doesn't work. And every now and again, believe it or not, grandchildren can still be a forced heir. It doesn't happen a lot, but that's something why it's really important to see a board certified attorney, and that's part of the reason why I kind of put up a little bit of a resume beforehand was it is important to go see a board certified attorney because we can pick these issues out because you don't want to pay a lot of money to a lawyer, get your estate plan done, and next thing you know, it's invalid because you have a forced heir out there that you didn't leave property to. Um, for the forced portion, the amount that the law says this is the minimum you have to leave this disabled child or a child under 24. If you only have one forced heir, it's going to be 25%. If you have multiple children, two or more, the forced portion is going to be 50%. So keep that in mind. And remember, it's 25% for mom's estate and 25% for dad's estate or the other parent's estate. So it can result in a significant amount of money that has to go to that child. And what we don't want to happen is the money goes free of any trust, outright, gets paid out, the check's made payable to the disabled child's individual name. That's where we see problems. And it's not just losing Medicaid or losing SSI. It's all these predators that come out of the woodworks, and they're supposed to be advocacy groups. And next thing you know, the child's money's all gone. So that's what we're avoiding. Okay, our hope and pray plan, sometimes it works, most of the time it doesn't. On the good side of it is if you do this, if you leave everything to sister who's going to take care of brother for you, disabled brother, yeah, your child's still going to keep their government benefits. There's not going to be any lapse of benefits or anything like that. But as you can see on the bullet points, the downside if sister gets divorced, I'm going to tell you, half of that's going to most likely will go to the divorcing to sister's ex-spouse. So we really want to be careful. Same thing if sister gets sued and the creditor takes a judgment against her and they may be seizing, and the creditor will have every right to do this. They will seize that money. Um, Mismanagement's another thing we see. The money can just get spent. So there's a lot of problems with leaving it to another family member who's going to take care of your child. We really want to exercise caution when we do this. On the third option, the spin down, it's basically what it says. Child can keep up to $2,000 in their bank account. I tell parents, I like to see that not more than $1,000 at any given time just to be safe. We can pay down debts, pay for some services that aren't covered by Medicaid or any kind of insurance. Um, the good thing with spin down, if you do it efficiently and by the time Medicaid tells you to do this by, they'll usually give you 30 days. You'll get a letter from Medicaid saying, we've noticed so and so has $4,000 in their account. You have 30 days to bring that down to 2,000. You buy a washer machine. I always say, look, if your child has different hobbies, different interests, spend the money on that. That's what it's there for. Spend the money, go wild. If your child likes to paint or bowling or something like that, go get the really good stuff for your child. Child likes the video games, get the really good stuff. So spend down is pretty easy. Um, as you can see, downside of it, there may not be income available to your child. If any of that money was earning a little bit of interest, you're going to lose the interest if you have to spend it down. In essence, losing income. And once the money's spent down, there's no long-term access to that money anymore. It's gone. It's different with a trust, though. With a trust, there's still the long-term access. So, all right, let's spend just a couple of minutes on able accounts. These are really good idea. Um, there's some downsides to it. I think it really depends on the amount someone's getting or the amount of their overage. Um, the big problem with the able accounts is a low contribution limit. As of 2026, any person actually can only give an able account can only have 20,000 be given $20,000 in 1 year. So dad can't give $20,000 to the able account and your uncle can't chip in another $20,000. It doesn't work that way. It can have a maximum of $20,000, and the child can only have one able account. The good news, though, is that the child's still going to qualify for Medicaid and SSI, um, and the child's going to be the account owner. So that's kind of a nice thing. But in order for your child to be the account owner, they're going to have some type of ability to comprehend what their bank account is, how to handle their bank account, things of that nature. Another downside to the able accounts besides the low contribution limits is that if there is any money left in that account and a child passes away, whatever money's left in that account will have to go back to the state of Louisiana, almost like a beneficiary type policy. Um, but again, it's just balancing the pros and cons. If child has 10,000 extra dollars, we can't spend it down. What do we do with this money? Let's put it into an able account. That's what it's there for. You don't necessarily want to create a special needs trust for $10,000. So the able account is a very good alternative. Um, the money needs to be spent on this thing called qualified disability expenses. We have everything on the screen for you. However, I'm here to tell you, there are no able account police that go around looking at what did you spend this money on? Not in an able account. On some special needs trusts, they may do that from time to time. Basically, anything you need to spend the money for your child, you can spend the money with an Able account. Not a big deal. All right. Really cool thing about an Able account is any income that is earned or any growth of the money held in an Able account is income tax free. And whoever gives money to an Able account, making a gift to that child through the Able account, you do not have to file a gift tax return. So that's another big benefit of it. And as you can see on the bottom of the screen, if your child understands, has some understanding of money, and there's an idea here of a sense of self-worth. I'm taking care of myself, things of that nature. Those are hidden benefits of Able accounts. Okay. And plus it's basically a checking account, debit card. So if you need to spend the money, it's really easy to do so. You don't have to jump through a whole lot of hoops with Able accounts. That's why we're big fans of them. But they're limited though. All right, so this is the big one. This is the one that we're all here for, special needs trust. I could probably sit here and talk to you guys for 6 hours on special needs trust. Um, Not because I like them that much, but because there's so many rules and regulations regarding special needs trust, and they're just an all-out wonderful way to plan. And in my opinion, it's the best thing you can do for your child if your child's going to be on Medicaid one day or SSI. So let's go ahead and get into the special needs trust. Um, if you can answer yes to any of these questions, you probably want to get the special needs trust done. Is your child vulnerable to undue influence? That's one that many parents don't think about. We don't consider that. Again, we want to stay away from the ostrich picture with the head in the sand. Unfortunately, there's a lot of predators out there, and they will take advantage of disabled adults. Even though it's your child, they may be an adult, and they will take advantage of them. Do you want to make sure, that your child has lifelong access to financial resources? What about a life care plan? Do you think your child will need a life care plan? Hey, a special needs trust is a wonderful way to do that. If your child inherits from you, are they going to lose Medicaid? Are they going to lose SSI? So these are all the questions that if you can answer yes to any of these, you most likely need to get a special needs trust done. Special needs trust, any trust, as far as that's concerned, I'm going to demystify it. It's not super complicated. All it is just a box or a bucket. That's all a trust is. It's just a holding vehicle, holding bucket that holds the property for someone else. And in any trust, you're going to have three parties. You're going to have a settlor. That's the person that creates the trust. That'll be you as the parent. Then you're going to have a trustee. That's the person in charge of the trust. That will most likely be you as well. All a trustee is just a manager of the trust. And of course, you'll have a beneficiary. That's going to be your child. They're going to be the ones that receive the benefits from this trust. They're the ones who receive the property, receive the money. That's who a beneficiary is. And that's it. That's the three parties to a trust. In all trust, they're always going to have these same three parties. So as I said, it's basically like a chest. You're just going to put, whatever inheritance that's going to go to your child, your special needs. I think I was freezing for a second. Whatever property that was going to go to your special needs child, it's simply going to go into the chest. Whatever you want to leave your child, as long as it satisfies our forced heirship laws, it can go into that chest. Okay? One of the things that we want to make sure our parents understand is, remember, if you have one child, disabled child, they're a forced heir, they have to receive 25% of your estate. The beauty of it is the way we create our special needs trust, the way we do our estate plans, your executor is going to have the ability to pick and choose what assets they want to fund that trust with. So the important number is the value of that special needs trust needs to be 25% of the value of your estate. Okay. So for instance, if you have a house that's worth $300,000 and you have other asset, you just say your total estate is $1 million, or just say for ease of example, $100,000. We just have to make sure that $25,000, and that can come from stock, that can come from a partial interest in a house, that can come from a car, believe it or not. We just have to make sure that the value of $25,000 gets put into that trust. Okay. The really neat part about special needs trust is that we can assure, and even after you're gone, long after you're gone, that the inheritance is properly overseen, is properly managed. You'll love what your child's going to receive financial support through the special needs trust for their lifetime. The magic of it is the assets, they're used for the benefit of your child, for the sole benefit of your child, but they're not owned by your child. That's why we can still qualify for Medicaid and SSI. If you look at the last bullet point, this is something that I ask everyone to just kind of think about it. We definitely know if, mom and dad, I die, I want my wife to be in charge of my son's trust, whatever the case may be. Or I want my daughter, who's super responsible, very, very mature, 28 years old, I want her to be in charge of the trust. What if something happens to my daughter? What if she can't be in charge of the trust? We want to start thinking about who is the line of successors going to be. Well, if my daughter can't do it, then I want my cousin, who's a CPA, to do it. So we kind of want to start thinking a little bit further down the road of what happens if Jim can't be in charge of the trust? Who's going to be the next person to manage those assets? This is all part of that life care plan, making sure we have continuity of ownership or continuity of management, so to speak. Um, there's 4 different kinds of special needs trust, but for the purposes of this presentation and the purposes of my 22 years of practicing law, we're only going to worry about the first two. The first party or self-settled special needs trust, and then the best, a third party special needs trust. We are trying to get to the third party special needs trust. That's the best one we can get. Okay. The pooled special needs trust and the qualified disability trust, we don't do those here. There's not really a reason I've found to do one of those for my clients in the past 22 years. All right, let's start with the first party special needs trust. Think of this. You're a single parent, whatever the case may be. You never get around to getting your will done. You don't do any kind of planning, and all of a sudden you pass away, and you have 2 children, Bill and Sue. Your son Bill has special needs. Bill's going to get his 50% inheritance. He's going to get 50% of the estate because you're dying without a will, and so it gets split evenly between your 2 children. That money, since you did not have a will, has to be paid out to Bill. That means that's Bill's money. And if it's the child's own funds, we have to do the first party special needs trust. Child's still going to get Medicaid, still going to get SSI. Everything's going to be great that way. But there's some big time drawbacks on this. Number one, it has to be an irrevocable trust. We can still create the trust. We just can't change anything on it. Number two is that we have to pay back the state of Louisiana Medicaid in the amount of any assets left in the trust when our child dies. That's a big drawback to it. We're going through that right now with Louisiana Medicaid, and they've gotten a lot tougher over the last probably 4 years, I would say. Early on in my career, we kind of write some letters to the state Medicaid office, and they'd write us back, and next thing you know, the trust is terminated, and we don't owe the state anything. But now they want to see accountings, they want to see what's left in the trust, and the idea is if the state paid, just say $100,000 for your child's care, your child passes away and there's $50,000 left in the trust, the state's going to want that $50,000 and they will get it. So we want to avoid first party special needs trusts as much as possible. So how do we do this? We do a third party special needs trust. We do some planning ahead of time. And as I said a little while ago, these are going to be assets that are not owned by your child. They're going to be owned by the trust. If the parents do the planning ahead of time, we create the third party special needs trust. And the beauty of the third party special needs trust is under no circumstances, no ifs, ands, or buts about it, we are not paying back the state of Louisiana. That money is going to go down, however the parents want it. If their disabled son Bill passes away and there's still $50,000 left in the trust, mom and dad can say, we want the money to go to X, Y, and Z. So really a lot of control here. Mom and dad can change the terms of the trust at any time. If they created it, we're going to create this thing as a revocable third party trust. That means that mom and dad chose Susie as their backup trustee manager of the trust, and they have a big falling out with Susie in 10 years from now. They can go into the trust and change it and say, we want our cousin Jenny to be in charge of the trust. So there's a lot of different things, a lot more options available if the planning is done ahead of time. A lot of people kind of have a misunderstanding, but a special needs trust can have more than one beneficiary, especially if you have very young children. We can put other beneficiaries on there. And the trustee has very, very broad discretion on when and when not to make distributions out of the trust. So really some neat things that we can do with third party trust. And for those of you that may be having a little bit of confusion still, regarding first party and third party. Another example of a first party special needs trust that we see in our office from time to time, it's a tragic example, is, a child gets in a car accident, personal injury, they're going to pay that, there's an insurance settlement for $300,000. That money, that's really the child's money. So if it's funded with the child's own money, like an intestate inheritance or a personal injury wreck, we have to do a first party special needs trust. But if grandpa says, I want to leave, I want to make sure that my disabled grandson Bill is taking care of the rest of his life, and I'm going to leave him $700,000. We can do that through a third party special needs trust. So I hope that kind of explains some differences. Um, so again, say we have the big falling out with the person we've picked, Sue, as our backup trustee. Who are we going to pick as a new trustee? Well, these are the three things to consider. Are they going to do they have some backbone? Are they going to be an advocate for a child? Are they going to fight for a child? Are they going to go through the rigmarole of dealing with Medicaid and all those kind of things? The person's going to have to be able to do that. Are they going to be accountable? Are they going to keep good records? Are they going to not spend the money on their own selves? That has to be a big consideration as well. Are they good record keepers? It's not rocket science as far as the record keeping. We tell everybody, look, just do it the old-fashioned way. Get your paper bank statements, pay the extra $5.40 every month, whatever it is. Keep paper records of everything. You spend money out of the trust, you need to keep a record of it. The easiest way to do this, keep the bank statements because that's going to have a picture of everything you're doing on behalf of that trust. Another consideration is they have to be financially responsible. They cannot be a spendthrift. If you're going to choose, excuse me, if you're going to choose your daughter Sue to be in charge of this trust, and Sue's never met a credit card she doesn't like, you may want to think of someone else. Because we don't want money to start conveniently disappearing from this trust. Okay. All right. The big no-no, we've made a lot of, what do you know? Congress actually listened to us. A bunch of us in the special needs trust community, we've griped and complained and sent letters and done all kind of committee hearings because the rules used to be outrageous. You couldn't spend the money on food, clothing, and shelter for special needs trust. And every parent says the same thing. Well, what else do you spend the money on? And we're like, there's not a whole lot. So Congress finally got rid of clothing and food. So you can buy all the food you want. You can buy designer clothes for your child with the special needs trust money, no problems. The big no-no though is shelter, basically rent payment. The state Medicaid does not want to see any money out of that special needs trust being paid for rent. That's our big no-no. Um, but in Congress's brilliant mindset, a special needs trust can own a house, but it can't pay for rent. So, yeah, take that for what it's worth. Yes, there's no ifs, ands, or buts about it. You can take that $300,000 in that special needs trust and you can go buy a house. The trust can own a house, no problems. But boy, the moment that trust starts paying rent to XYZ apartments or whatever rental place, you're gonna get in trouble with Medicaid. The other thing we don't want to do is make significant distributions directly to the beneficiary. Because again, things are going to accumulate in there in the beneficiary's bank account. And next thing you know, they're going to be over that $2,000 limit. So the best practice is instead of giving the beneficiary the $1,500 to go buy a new refrigerator or whatever, you just buy the refrigerator online and just buy it from the trust. The trust pays for it. The other big one is we want to make sure that the assets are not commingled, meaning what's held in that trust has to stay in that trust. We don't want that $50,000 making its way over to the trustee's bank account because it's easier to write checks out of. That's a big no-no. The money needs to be separated. Whoever's in charge of the trust, they need to keep their money away from the trust money. And as you can see on the right-hand side of this slide, these are all the things that a trust can pay for. A home, school tuition, travel expenses. It can buy a car, it can buy a handicap van, all that kind of stuff. Hobbies are a really big thing. I think I said it a little while ago, we tell everyone, go wild on the hobbies. This is the way to think of it. Think of it as a supplemental needs trust. What can you do to supplement that person's way of life, their quality of life? That's the proper way to think of it, not special needs trust, a supplemental needs trust. Okay. Um, we love lists in our office, so here's our top 10 benefits of having a special needs trust. Of course, numero uno, we want to protect the assets so that they can maintain any government benefits that they're receiving. Um, if it's done correctly, I like to point out number four. If we have the special needs trust in place, then say grandpa wants to leave that gift of whatever, $700,000 to the child through their will. Well, instead of saying I leave $700,000 to Bill individually, grandpa can leave it to the trust because it's already in existence. So that works out really, really nicely. again, protection's a big issue with our clients. We want to make sure that their children are never, ever taken advantage of. Rest of the list, of course, of avoiding Medicaid payback, but only if you do it the right way. Oh, I wish I had a poll on here so I could give everyone whatever, a pop quiz. Only a third party special needs trust avoids the Medicaid payback. Again, lifelong advocacy is a big deal. Continuity of management of the trust. Those are all the big benefits of having a special needs trust. And not to mention, if you know, I've had clients in the past that have had special needs children, and they've caused damages. They've gotten in physical altercations with complete strangers, and they've gotten sued. Anything held in a special needs trust is 100% protected from your child's creditors. Okay, so if your child makes a mistake, accidents happen. If they push something off of a building or a roof or do something, break a window, creditors cannot seize any of the assets in their trust. So that's a big benefit. All right. Um, there's a bunch of, I mean, look, it's not just being born with a condition. There are a bunch of different things that we see day to day in our office that causes a child to have special needs. That's a reason for us to do a special needs trust. And as I mentioned a little while ago with the example of the car wreck, yeah, personal injury, that's a big one that we see. But inheritance, that's probably the number one issue we have in our office is when clients don't do their planning, they die, or they do improper planning, and they have their kid's name individually in the will, then we have to do a first party special needs trust. And the last bullet point on the screen, of course, look, we understand your heart's in the right place, family members making these gifts to the child or inheritances that you're leaving to that child. We just have to make sure it's done in the right way. So everything has to match in a special needs trust. And it's not just your mom and dad's wills. Look, if brother or sister want to leave property to child, to their sibling, their will has to have that special needs trust in there as well. Um, Kind of jumped on a few of these. Bad news with special needs trust, with especially the first party special needs trust, the income does get taxed, so we can't really get around that. And the trust has to pay the taxes. It's a little bit, it's a higher rate than you would normally pay. Um, Again, coordination with the estate plan is really, really important. If you have a parent that may want to leave an inheritance to your special needs child, it has to be left to the special needs trust. And just as a little quick reminder, revocable, if we do it the right way, we can change the trust at any time as long as mom or dad are still alive. If the trust is irrevocable, first party special needs trust, we're stuck with it. Once it's in place, we can't change the special needs trust. So a lot of misconceptions, a lot of bad information on the internet about special needs trust out there. Number one, it's not poverty planning. We're not planning to make your child poor. The special needs trust is the opposite. It's making sure that we save the government benefits and enhance your child's quality of life. Um, Another big misconception we see or myth is, well, I don't have millions of dollars. I don't need a trust. That is not true at all. As long as it's going to be over, I say, really $40,000 or so, that's going to go to your child, you're going to need a special needs trust. One day my child may not need these benefits. Well, great. We can get rid of the trust at that point. But until that point, we want to have the special needs trust provisions built in there. Um, we touched on this in the very beginning about I'm just going to leave everything to Sister Sue. Sister Sue will take care of Bill. And we kind of showed you the problems that can arise with that, especially if Sister Sue ever gets divorced, Sister Sue ever loses the money, gets sued. There can be some problems with that. Okay, so those are some of our misconceptions. Um, Basically, everyone needs to plan. Certainly, if you have a child with special needs, it is absolutely critical that you do a special needs trust plan. Okay. Let's see. We just kind of always like to say, if it's so important, why doesn't everyone do it? Well, there's a bunch of different reasons. Number one is a lot of our parents, they feel overwhelmed. You guys have so much going on in your life right now. There is no ifs, ands, or buts about it. Having to stop what you're doing, leave work, find a babysitter or someone to take care of your child so you can go meet with the attorney to get this done. It is overwhelming. That's why we make it as easy as possible for our families. We don't know. A second reason is we don't know what we don't know. Lack of knowledge is a big problem. So thank you again. You all deserve some congratulations for coming to this or attending this webinar tonight, because now you know. So what was there's a oh gosh, it's been on the news, the Biggie Smalls thing. If you didn't know, now you know. So hopefully we can all use that now. I had the ostrich with the head in the sand. Same thing with this picture. We have family members, they're just in a denial. They think things are going to get better. The autism is going to get better. There's not going to be major issues when they get older. Sometimes that's true and a lot of times it's not. So and as you can see, the impacts can be pretty severe. The confusion, if you don't have a plan in place, then the law is going to speak for you. So we really, really want to watch out for these things. And a big one is caregiver burnout. That's something that a lot of people don't recognize until it's too late. And it's very difficult, caring for a child with special needs. Especially, it's very difficult caring for an adult with special needs as well. So caregiver burnout's a big thing that, families need to consider. All right. We have another QR code. We have a special needs trust or special needs planning bundle on our website. And I think when you hit that other QR code earlier in the presentation, all this stuff should pop up. But I'll leave it up for you guys. And I see we have some questions in the chat room. All right, so I'll try to answer some questions. Oops.
Yeah, I was just about to mention that to you, Chip.
All right. All right, so hold on one second. And I know we're running a little bit over time here. All right, disabled adult child benefits are also entitlements available to adult children with developmental disabilities. I'm not sure.
That was just a statement, not a question.
Oh,
She
okay.
was
All
just
right.
clarifying. When you were talking about the entitlements versus like means tested programs, Kathy was just adding a little bit of extra context there for people whose parents are receiving
Yeah.
Social Security retirement benefits. Their disabled adult children are also entitled to benefits, is what she was saying.
Okay. Okay. If your children are too young at 10, they're not going to qualify for SSI at this point. Whether or not you should apply, I think the answer is if it doesn't hurt, apply. If it will hurt you, don't apply. But I don't think they're going to get the SSI at that young age because they're going to base it on mom and dad's income. If a child receives a large lump sum, how long do you have to put the money in an ABLE account or trust account? That nasty letter that you receive from Medicaid, oh, it's not nasty, but the letter you receive from Medicaid will tell you you have 30 days to do this. Or what's been happening with some of our clients is Medicaid's going to set a second meeting with you where you have to go meet with them and you have to have it done by that point. There's no hard and fast timeline for that question, you know, and it's just take care of it sooner than later is the best answer. If the house is in a trust, can the trust pay for maintenance insurance? Absolutely. If the house is in a special needs trust, the special needs trust can absolutely pay for maintenance insurance on the house, fixing the roof, all that kind of stuff. All right. When can my husband and I come to your office? Yeah, if anyone likes to set up a meeting, please give us a call. Our number's on the screen, and we'll be more than happy to meet with you and discuss everything. If you move to a different state, do you have to redo the tutorship? Great question. Okay, no. I get to put on my constitutional law nerd hat on for a second. We have something called the full faith and credit clause in our Constitution. Basically, what this means is client is in Texas, they have a severely disabled child, they have a guardianship in Texas. They move permanent guardianship. They move here to Louisiana. All I do is I take that the judgment from the Texas court saying mom and dad are the guardians of child. And the Louisiana court says, okay, this is valid in Louisiana. Here's your Louisiana judgment with the Louisiana language in it. Same thing. If you move to Texas, you move to Alaska, and you have a continuing tutorship here, all the lawyer will have to do in that next state you move to is get that court to issue another judgment. So it doesn't have to be redone. They just say, okay, here's your new judgment according to the laws of the state of Alaska. So it doesn't have to be redone. What is the best state to get an ABLE account? I do not know the answer to that question. I don't know if there is a best state. It's pretty much stuck at all the states, I believe, at $20,000. So, yeah, I think they're going to be the same everywhere. All right. Sending out a link to the recording. I think that may be, oh, Claire, you got that one. Cost to establish a S&T third party cost. I'm not a big fan of, we don't quote our cost over the phone because it's just, there's too many variables. It's like asking somebody, what does it cost to go to the grocery store? Well, it depends on what's in your shopping cart when you check out. We have a standard fee range I can tell people, and it's going to be between 3,500 to 4,500. Um, most of the time it's going to be right around that $3,500 number. Sometimes it'll be 3,900. It just depends because you may have some things in your trust that are really, really detailed, and that may cost a little bit more. But what we do is as soon as you meet with us and we get all the facts from you, we're going to tell you exactly how much it costs. We do not hide costs in our meetings. What is it? Okay. All right. Did I get all the questions? Ooh, that was fast. Okay. Well, I very much thank you everyone for coming today or this evening, watching the presentation. Why isn't this working? Okay. Okay. There we go. Please excuse the technical problems here. But again, if anyone has questions, anyone would like to meet with us, you're always welcome. We really, really invite you to meet with us. Just give us a call. This is something that's really near and dear to us, and we just enjoy the opportunity to get this information out to you guys. Let me see if I can answer a couple quick questions, and I'll get you out of here.
Let's see. Tanya asked what's the max limit for enable account? Isn't it max yearly contribution? Is there a total max as well?
Yeah, the total yearly contribution in any given year, it cannot exceed $20,000. So now the Able account, just say last year it was 19,000. I could give 19,000 to my son's Able account in 2025, and then I can turn around on January 1st, 2026 and deposit another $20,000 in it. It's a yearly thing. So in 1 year, you can only give $20,000. All right. Okay. All righty. Well, I appreciate it very much, everyone, and I hope everyone has a great rest of the evening. And thank you, Claire, and thank you to the Autism Society. We sincerely appreciate this. So, thank you.
I think, Tanya, I think the max balance limit in Louisiana is 500,000. But I didn't take too long to look into that. But the maximum amount that can be in balance in the able accounts does vary by state. And I think in Louisiana it's 500,000. But
Yeah,
I'll there when I send out the information, I'll also send a link to the Louisiana able account website, and that has like all the details for our state.
yeah, and just as a quick follow-up on that one, if you're it really if you're going over, $100,000 or something like that, you need to have the special needs trust in there because we don't want to pay. Remember, able accounts have to pay back the state. If you do have an able account for your child, spend that money first because it has to pay back the state at the end of your child's life. Spend the able account money first. The special needs trust, if it's done correctly, doesn't have to pay back the state. So I hope that helps. But I appreciate it. Please reach out if you guys need anything. And that's it.
Thank you, Chip. Thank you everyone who came and attended today.
All right. Thank you. Appreciate it.